Thank you all again for attending the first series of Lawyer Up. My name is Nicole Hansen. I am the Executive Director of Out for Justice. Out for Justice is a grassroots group that advocates for formerly and currently incarcerated individuals. And I'll pass it over to Matt from BALT.
Yeah, thank you for joining. I am Matt Parsons. I'm the community lawyer with Baltimore Action Legal Team, or BALT. And BALT is dedicated to politically conscious lawyering and using creative collective solutions to support the movement for Black lives in Baltimore. And we're very excited to have you here tonight with Nicole and Out for Justice and our wonderful panelists. So yeah, thank you for joining.
Yeah, and just for you all to know, the vision for Lawyer Up is, it's not a new idea. It's something new for Baltimore, but it is an ecosystem, and it's a space that's being held by many of our allies, even across the state, as we have one of the panelists, Kiana Johnson, who actually holds a space like this, where we engage with the legal community, and we bring the legal community with community, and we talk about legal issues in ways that attorneys can show up in our advocacy space. And so that is the vision for Lawyer Up, to make sure that in a place like Baltimore, which is a huge city, and where people have all kinds of different ideas and visions, that this series of Lawyer Up, our vision really is to hear from you, the community, about the different legal challenges you're having, or the different legal issues you want to learn about and hear about. And then it will be our job at BALT Out for Justice to bring the people to you, bring the experts to you, and bring the information to you. And so thank you. Today, you will be hearing from legal minds and legal practitioners. First up, you will hear from, not first up, but I'll start with the woman first, because there are two men. So we'll start with the lady first. You will hear from Kiana Johnson. She is the Executive Director of Life After Release, an organization that does immense work in the Prince George's County and DMV area. And I'll let her tell you a little bit more when she speaks, but her work is a phenomenal set of bodies of work that she does, from creating Baltimore's first participatory defense hub in Maryland, right? The first in Maryland to usher in participatory defense in Maryland, to bailing Black mamas out of cages, to also leading the Prince George's County Court Watch. Court Watch PG is led by Life After Release. And even the work that they do around policy right now, they are leading the work in ensuring that our courts have virtual access and even streaming access, but more importantly, getting individual people access to the courts, as it is their constitutional right. And I'll pass it to Matt to introduce the gentleman, if you will.
Yeah, thank you, Nicole. So on the topic of the lawyer-client relationships and the ethics that are involved, we have Professor Rubinson from the University of Baltimore, who will be talking to us about a lot of the basics that are involved with those relationships, the duties of a lawyer, and what to do in your relationship with your attorney. If there is a disagreement or any kind of unethical conduct, where do you go? We also have Brandon Burrell, who is a private attorney who can speak to the work dealing with clients, advocating for them, and trying to remain ethical when you're working on their case. So those are our three panelists for today. And just a reminder that this workshop is being recorded. So we will be sharing this on our YouTube page for BALT, and that will be available later on for anyone who'd like to watch. And so we'd like to start off with just a quick tech tutorial if you're joining us on Zoom. So if you look here, you can see at the bottom a list of controls. You should see them if you're on the computer or the phone. There's a mute and unmute button that it should remain on mute when you're not speaking. But for the question and answer and discussion portion, we definitely encourage you to unmute yourself and engage in the conversation when it's appropriate. If you do want to join us on camera, you can click start or stop video here, whatever you're comfortable with. We're just glad to have you in this space. There's also a chat function. So if you click this chat button, you can see how you can ask questions as panelists are talking, so that later on we can go back to you and that you've put down your thoughts in the chat. And then if you need to leave the session for whatever reason, please see the end call button, and that will allow you to leave the Zoom call. And so with that said, Andy, could we take down the Zoom screen? And I just like
those of you, can I say something really quickly? Those
Yeah.
of you who are looking at that pictograph, like, why are we doing this? It is really important for, especially us at Out for Justice, to make sure our people understand technology, right? Like we like to always assume that people know what we know, and that is not always the case. And so I thought that was important to help people navigate Zoom as we're coming into a world where Zoom is the norm, and in-person is becoming not. We thought it was important to make sure that for those people who may be struggling with navigating Zoom, that was an option.
Yeah, thank you, Nicole. And so I have, just a quick question for those of you joining the space. Maybe you're a little less, familiar with like the legal ethics that attorneys are bound to, or you've had certain experiences with lawyers in the past that you'd like to learn more about how to handle in the future. But for those of you joining us, like what kind of questions do you have coming into this space? What are the things that you might be hoping to get out of this conversation?
And if you want to wait until the discussion is going on, that's fine. But again, this is about you. This is about people who have been impacted by the criminal legal system or are currently dealing with court cases right now. And this is about what should you be expecting from your attorney? What does the relationship look like? What is ethical and what is not? And so don't be shy to throw a question in the chat or raise your hand, even as we get started. But thank you.
Yeah, so just want to leave space for anyone to join in the conversation. But of course, there will be a Q&A and discussion portion later on. So why don't we move on to the presentation that Professor Rubinson has for us tonight. Professor Rubinson, I'll be sharing my screen. And yeah, let's dive in to the topic of lawyer-client relationships and ethics.
Okay, well, first off, it's a real pleasure to be here, and thanks to Matt and Nicole and all the work that Out for Justice and the Baltimore Action Legal team do for the city. I spend a lot of time in the law school working with students about how to be ethical lawyers and socially conscious lawyers to help folks, because it is a way to help people being a lawyer. It's a helping profession. So it's exciting for me to be here and really have a conversation with you all. Hope I can contribute. So thanks to Matt for jazzing up my PowerPoint slides here, because they were pretty boring before I did it. So we can go to the next slide. Okay, Andy, thank you, Andy, for jazzing up the slides. I'm pretty basic. Okay, so, lots of people, including the folks here, have experience with lawyers. Lawyers do a lot of things that you don't see on TV, or maybe that they don't do, that you haven't seen them do in your own personal experience. So there's a lot more lawyers do than argue things in court. Lawyers, as I said, are helpers, and they can give you advice about any number of things. We're so impacted by the law, not only under the criminal justice system, but with landlords, with family law, getting benefits, you know, you name it. Lawyers can really be helpful. And there's different ways to resolve situations. Again, it's not all about court. There's something called mediation, actually, which is a fancy word for it is alternative dispute resolution, where you can actually try to get past conflicts without going to court. And lawyers also write lots of documents, or can help you write documents, expungement petitions, advance directives, or actually forms which tell hospitals what you would like done in the event you have medical options, and they're important, and lawyers can prepare those. But what's also important when you're dealing with lawyers is lawyers are experts in the law, but they're not experts about you. You're the person who knows about your life. You're the expert. You know what your needs are. You know what your goals are, what you think is important. And so it's your job when you meet with a lawyer to really share that with your lawyer, so she knows how best to provide services for you. So I would approach it as a partnership. So it's not like the lawyer's the boss, it's a partnership, so you both can move forward towards what you think needs to be done. Okay, next slide. So getting a little more specifically into ethics, there are things that a lawyer cannot decide for you. It goes back to what I said previously, that you're kind of the person who's in the driver's seat here. And for example, if you're in a case with your landlord, settling a case in civil disputes, not criminal, only you, the client, can decide to settle a case. The lawyer can't do it on her own. That's unethical. Now, in a criminal case, only you, the client, can decide to plead guilty, waive a jury trial, or decide whether to testify or not. You can't be forced, or you shouldn't be forced into anything. A lawyer can advise you to do one thing or the other, give her best advice about what they think you should do, but ultimately it's your decision. And it's important, I think, to recognize that these big things rest with you, and don't be forced into anything. You're the boss here. Okay, next slide. So this is a bit, I teach a lot of classes on this, but I thought I'd pick out some things that are important in terms of what a lawyer, an ethical lawyer, has to do for you. One of them is to communicate with you. If you have questions, if you need information, it's the lawyer's job to speak to you about them. Now, lawyers are busy, they have a lot of clients, but if you need information, an ethical lawyer will get back to you, will speak to you to answer your questions, to provide information that you would like. Lawyers also don't know about everything. For example, I'm not a criminal defense lawyer. I know about doing that. I've done some appeals, but that's not my expertise. I do know a lot about other things. So lawyers need to kind of be aware that they don't start going into things that they really don't know much about. Lawyers have to tell the truth, in courts, to judges, to other people they speak to, and most of all to you. There needs to be honesty and candor when a lawyer speaks to you. Now, what's important too is when you speak to a lawyer, everything that's said there is confidential. So in other words, the lawyer ethically can't start blabbing about what the lawyer learns to, his friend, or to the newspaper, or to anyone who is not his client without the client agreeing that the information can be shared. There's a few exceptions to it, but the basic principle is what's discussed with a lawyer stays with the lawyer. Lawyers also should be clear about what they've agreed to do for you. It might be about a particular case, but they won't necessarily handle another case that you have. So it's important for the lawyer to be absolutely clear with you. It's the lawyer's job to do this, about what they're going to do for you and what they are not going to do for you. And for lawyers who are charging fees, it's important to be clear about what the fees are. And although it's not required, almost all lawyers will put that in writing. They at least have to be clear about what the fees are. And again, that's so it's clear with you. Okay, next slide is good. So sometimes a lawyer can tell you things you don't want to hear. Sometimes you might think a case is strong, or that the law says a certain thing. A lawyer might disagree with you or tell you that what you think is not true under the law, or your case is not as strong as you might think it is. That's not unethical. Actually, lawyers are there to be honest with you. Otherwise, they wouldn't be doing their job. Another thing that is not unethical is, I said earlier that lawyers have to communicate with you if you have questions or need information, but lawyers are busy and they have lots of other people that they are trying to help. And so absolutely, they have an ethical obligation to speak to you if you're a client, but sometimes it's not possible to get an immediate response if you're emailing or calling or whatever. And a lawyer also can't do something that a client wants to do that would violate a lawyer's ethical responsibilities. For example, a lawyer can't lie in court. That's unethical. So next slide. So what happens if you think your lawyer has done something unethical? Well, first off, and this is always the first thing that should be done, is speak to the lawyer. There might be an issue with communication. There might be an issue with the lawyer or you not understanding what the representation involves. Sometimes just talking things out will, in the end, solve a problem and actually lead to a really good relationship with your lawyer. Now, if you do think something unethical happened, and these are sort of fancy names, but you file what's called a disciplinary complaint with a place called the Attorney Grievance Commission. Their headquarters are near Annapolis. And there's a form online in English and Spanish. All the information is there, and you can mail it to the Office of Bar Counsel. That's the person who moves forward with these complaints. Now, if you file a complaint, the complaint is going to be investigated by the folks in that office. They might think there's nothing to it, in which case it'll be dismissed. Others move forward through the system. And for the times lawyers really do some major unethical things, they can also ultimately be what's called disbarred. Their license is taken away and they can't practice law anymore. Now, these complaints, for the most part, lead to punishment for the lawyer themselves. So it doesn't give money or other types of relief to clients. What would do that is something called a suit for malpractice, which is when you're actually suing, you are suing the lawyer because the lawyer did something that was unprofessional, that was unethical, and you're asking for money as a result of what the lawyer did. So that's a very quick overview. I think that's the last slide. And I hope that was helpful as always. I'm looking forward to a conversation or any questions now. I'm happy to move forward as folks think would be most appropriate. And thanks again, Andy, for doing those slides.
Of course, thank you for providing the information.
Thank you so much, Professor Rubinson. I think we have one question from the chat, and that's from Eric, who asked, what is it called when you're trying to have a third party involved with your counsel session?
I'm not sure what is it called. I mean, that happens. I don't know of a specific name for it. What that does lead to is, I said that what's said in the room is confidential. If there's a third party there, the confidentiality doesn't extend to the third party, so they can go and say whatever they want about what was said in the room. So it does have an impact on that. So that's something to be aware of. Sometimes, you know, you need a third party there because of language issues or other things like that. So your lawyer can tell you a little bit about some legal consequences about having that, but I could go on and on. It'll be a little boring.
I would like to pivot that question to Mr. Burrell, and I don't want to skip over anything that you already had planned, Attorney Burrell, but I do want to pivot that question to you and hear your insight about the third party relationship, given that you are in a community attorney who, and not to say you aren't, Mr. Rob, but you're very clear that you're in the classroom, right? And so I really wanted to pivot that question to both Attorney Burrell and to Qiana as a practitioner, as being one of those third parties in the room. So first, I would like to get Attorney Burrell's insight on the third party.
Right,
So,
and
Mr. Burrell, could you please introduce yourself before going into that question?
yes, my name is Brandon Burrell. I am a private attorney. I practice primarily criminal defense in Maryland and DC. And I think that is an important question, and I think that comes up a lot in practice. A lot of the clients I represent, of course, they have family who are interested in the outcomes of the cases, friends that are interested. And a lot of times I'm talking to, the client as well as their family, their mother. So I tend to do it a lot, but just like Professor Rubinson had alluded to, it does have an impact on attorney-client privilege, having a third party there. If that third party obviously is someone like an interpreter or someone like a secretary or someone that's part of or an investigator, part of the legal defense team, then that's different. But if it's a family member, then that does impact whether the conversation I'm having with my client is confidential. But I think it's something that happens very frequently. I haven't ever really run into it becoming an issue. I have taken cases with individuals that are connected to organizations like Life After Release and whatnot, and so the people in Life After Release, they're third parties to the case, but they're also there to help the client, and I know that they're there to help the client. So I know some lawyers shy away from it, and that's the reason. That's at least one of the reasons, because they're worried about confidential information in the case getting out, and they're hesitant to talk to different organizations. But I have found typically that those third parties oftentimes can help in a lot of ways. They sometimes can articulate things to me that that the client may not be able to, and ask it questions, and may have additional information, may know about other witnesses that I wouldn't have known about otherwise.
Thank you. I want to be mindful that we have some questions queued up in the chat. But first, Kiana, I wanted to give you an opportunity to introduce yourself and if you have thoughts to share them on this topic.
Hey y'all, my name is Kiana Johnson. My pronouns are she, her, and hers. I am the founder and executive director of Life After Release, and I'm also a co-conductor with Harriet's Wildest Dreams out of Washington, D.C. And I just wanted to say, as we are talking about lawyering, we have to also understand that we're moving into a new age of lawyering. We have to be very creative around our defense lawyering and our defense mechanism as we are moving forward, only because of the way that defense attorneys are, so overburdened, how many cases there are. And when we talk about third-party authorizations and other people being involved, what I would like to say around that is that attorneys have to, a lot of the times attorneys will hide behind that when they are not necessarily wanting to be bothered, or they may feel as though their, their education or their tactics may be under attack. And so they will hide behind that attorney-client privilege. And so we have to be really creative. And as a legal practitioner, as someone who has been doing participatory defense in the state of Maryland for over the last 3 years, with over 27 people and saving 1,101 years of prison and jail time with 3 acquittals under our belt. I just have to say that we have to start looking at lawyering in a different way. And we have to get really, really creative with our defenses and how we're moving forward to get our people free.
Thank you so much, Qiana. I appreciate that. Eric, does that help clear up? I think you've gotten 3 different perspectives on the third-party relationship. So, this is about you and everybody else on this call. So I just want to make sure that that give you a well-balanced perspective at all about the third-party engagement.
In a way it did, but I wanted to make sure that there wasn't a name for it. Therefore, that if I was to bring it up, that I would know what I'm talking about. And
right.
If there wasn't a lawyer or a counsel that was on my side or had my best interest, that they would use the fact that I didn't have full knowledge of it and not grant me the third party.
So is it emotion? We're looking for a terminology because it happened to me, right? I was acting as a third party, not acting, I was being an advocate for my staff at a prior case. And the lawyer had agreed to a particular agreement, but the day of court, the lawyer changed it up, excluded me from the conversation, and used some tactics to make the client go along with what she wanted. She used you could go to jail. Those are triggering words for our people to, be like, okay, well, I'm just gonna go with what you said. But that's not what she had indicated on Friday. We had a very maybe almost an hour-long conversation where I asked her to repeat certain things. And so the day of court, she pretty much, blocked us out. And when I, engaged her and said, hold up, you had an agreement with your client. She used well, you need to send me a letter of notice or something. So can any of the attorneys clear up what is a thing that people can send to their attorney? Is it an email? Is it an emotion? What is it that a client can share with the attorney to say, hey, I want you to engage with these people or this person? Is there something like that?
I mean, it's a request that a client can make to their attorney, that the attorney also talks to the advocate. But keep in mind, the attorney has no obligation towards the third party or the advocate. The attorney only has an obligation towards the client. So, and I've seen, and I had mentioned this, that some attorneys, for some reason, they don't like it. They don't like to deal with advocates. They don't like to deal with other people. They only want to talk to the client. I don't have that perspective, but I also don't think that there are any rules that force the lawyer to talk to the advocate or whatnot. I think there's other factors you have to keep in mind. Is this a private case? Can the client go to try to maybe retain different counsel if they want an attorney that's also going to deal with, an organization or an advocate? The client could, if the attorney is with the, public defender's office, or it's a panel attorney, they can attempt to request a different attorney if it's really, that important to them that they want an attorney that's also going to deal with an advocacy group. But it's definitely not, a motion, and the attorney isn't required to do it.
Okay, thank you. I think it's some case law around it. I saw it somewhere, but I don't have it right now, but we'll move on. And just you all to think about that. You too, Professor, you're getting a glimpse into what is actually happening on the ground in community. And so when you are teaching in your classes, maybe you could be looking for case law that speaks to a lot of the issues that you will hear come up. Did we want to pivot to another question in the chat? But I also have a few questions that we got from members.
Yeah, so I actually want to uplift a question from Tanya regarding this conversation that was just had. Would that be called a mediator? So, could anyone go into like what a mediator's role is and how it could be different from, just any third party?
Sure, I could do that. And by the way, I have practiced. I actually was a legal services lawyer back in New York, where I'm from, where I was representing poor old people in Brooklyn, actually. So what a mediator is or she or they is a facilitator, which means not acting as a lawyer. To give an example, say in family law, let's say there are two parents who are having disputes about their child, and how to raise the child and how the parenting arrangements should go. Those folks would go to a room and there would be a third party there, the mediator, who is not there to make decisions about anything, is not saying you're right, but is there and has techniques to try to work with the parents about moving forward. Like, we have what happened, but how are you two going to be good parents to your children? What sorts of arrangements are you going to make, when you leave this room next year, 10 years from now? And if you go to court and start arguing about it, you're not going to be, that's not a good way to work together as parents. I'm just using family law as an example, but that's kind of what mediation is. It's people who are trained to resolve disputes in a collaborative way, not in a way where people are sort of, fighting with each other. So that's kind of, I'm happy to speak more about it. It's one of the things I'm involved with at the school.
Right. I wanted to pivot to Amon's question. And I would,
no need to pivot. I talked to Matt about it, so we're gonna hold off because I know we have other questions from your members. So okay. My question, we're gonna push mine back.
No, I think it's a really important question because I'm sure my members want to hear this question. I don't know. I feel like it's a good question to hold up, and then Darius is next. But I think this is a good one, Amon. And if I may, can I let me ask it, because we have advocates on the line that also engage with their people with legal stuff, and I think this is a good one. And so Amon asks, when does representation begin and end, right? And she's providing context. When, BALT get a lot of requests to help them after a person has been sentenced. Should they still expect help from their initial attorney? So I think that's a great question, because we need to know when the relationship starts and when the relationship ends. I see Brandon shaking his head. I see Rob, and I even see.
So also to give you some context, we at BALT are attorneys, right? And so I don't know if we talked about that. There are ethics issues when it comes to another attorney speaking to someone that's represented. Right. And so we always have conversations about when does representation begin and end. So that was another reason why.
Did somebody want to go first? Qiana, I see you.
Yeah,
Hold
sure.
on one second. Qiana, did you
So
want to?
I know the lawyers on the line are going to tell you what is like supposed to happen in theory and like what's on the books, but I'm going to speak to the fact that, you know, right now in our community defense, we have about 60 cases, 60 active cases in Prince George's County and throughout the state of Maryland, right? And not to mention the cases that we also have in DC under Harriet's Wildest Dreams, but particularly in Prince George's County, what I can speak to is that typically after what the problem that we have been noticing is that after a client has either entered a plea deal or has been sentenced, the public defender is out of there, right? They are gone. They are a lot of the times they are not filing a motion for reconsideration, which is very, very important because in the state of Maryland, you only have, and Brandon or one of the attorneys can correct me if I'm wrong, I think it's either 60 or 90 days in the state of Maryland to file what is known as a motion to reconsider that your attorney is supposed to file once you are sentenced or you have been convicted. And that motion for reconsideration is held in abeyance for 5 years with your sentencing judge. And so what we are seeing happen so often in Prince George's County is that our public defenders and our panel attorneys are out, they're out of there once that loved one, and we don't call them defendants, we call them loved ones. Once that loved one has been sentenced, they're gone. And so we have to follow up and chase them down in order to get them to at least do that part of it. Because we believe at Community Defense PG and Life After Release that our job is not done until we bring that person home out of incarceration. And one of our post-conviction tools to do that is the motion for reconsideration. So it's very, very important, being as though we only have that small window to file that motion. And so when the attorneys in Prince George's County, and it's very specific jurisdiction to jurisdiction, when they fall off after that loved one has been sentenced, we are usually in the chase down mode to try to get them to get back on the case. And then we have other issues about when that motion for reconsideration goes up, who's there to argue it if you've had a public defender, right? That has been those post-conviction methods and tools. We have noticed that the public defenders, not paid attorneys in most cases, most paid attorneys do their due diligence around filing that particular motion. But we have noticed that the public defenders, and we do sympathize with the public defenders because they have such heavy caseloads that they don't really have the time to do that thorough due diligence and file those motions for reconsiderations. And they're usually gone immediately after sentencing.
I would say that starting from the beginning, the first time a client even has a conversation with me, there are some responsibilities I already have in terms of, confidentiality and whatnot. Even if the person doesn't, retain me to actually represent them, there are, there may be some responsibilities there in terms of the very beginning of representation. Most of the time, in most, criminal cases, my representation is going to start, when I enter my appearance in the case, though. In terms of the end of representation, I absolutely agree with Qiana that for the motion to reconsider, you have 90 days to file that. You have 30 days to file for an appeal, and you have 10 days to file for a new trial. If you went to trial and got convicted, those are all important filings. I think there's actually case law to support that not filing a motion to reconsider in and of itself is ineffective assistance of counsel. Because after the 90 days, it's a problem if the attorney hasn't filed that. It's such an important filing that the lawyer should make. So that, I think, is part of the initial representation. If a notice of an appeal is filed, I think after the notice of appeal is filed and the case is in the appeals court, I think that is a clear end of the initial representation. And this is why. Because if you went to trial and you lost, you should not be having the same attorney that you had in trial represent you for the appeal. Because now you're automatically foregoing a possible issue on appeal, which is ineffective assistance of counsel. That lawyer cannot argue, oh, I was ineffective at trial, and now argue your appeal. So that's clearly the end when you get to the appeals court. A more gray area is probably probation. Let's say, you don't necessarily go to an appeals court, but you get convicted of something and you get probation for a probation violation hearing, a probation show cause hearing. It's more of a gray area, but probably the initial attorney should be handling the probation hearing and probation violation hearings as well.
I see you putting your thinking
That
cap
is
on,
definitely not
Mr. Rob.
happening.
That's not
That's
happening.
definitely not happening. That is Brandon. That is people are going to probation to VOP hearings without attorneys. That's
Right.
That is
And that's
100%.
right.
That's what's happening.
That's
Yeah,
where
and
we come in and we gotta fill the gaps for
And
government.
that's a problem.
Because,
And that's a problem. But the reason I say at least a gray area, because imagine, sometimes you could get probation for years. Let's say you represented this person at trial and they come back 3 years later on a probation violation. I think a lot of lawyers will push back to say, okay, am I obligated to still represent him 3 years later? I don't know, maybe. I think that one's at least a gray area. In terms of the appeals, okay, that's clear. It's definitely over when you get to the appeals court. But I think the probation, it's more of a gray area.
what do you think, Rob? I see your thinking finger.
Yeah, occasionally it happens. Yeah, I mean, this is such an interesting conversation. I think, Qiana, you also made the point, what's the rule? And then here's what really happens. And the two don't always go together. We all know that. And it's so frustrating. Like, you can't do that, but how do you get from here to there? But what I can tell you is the law about when the representation begins and ends. And I'm going to speak sort of at a sort of abstract level, which could probably only go really far, is it's the lawyer's job to be clear as to whether the lawyer is representing the client or not. If it's unclear, the lawyer's on the job. So in other words, it's the lawyer's job to say, I represent you such and so, I don't represent you on such and so. So it's the burden on the lawyer to be clear as to whether he's minding the shop or not. Now, that's the law, but as Qiana said.
That's fine. That's fine. We appreciate that. Because we have a couple of questions and I want to consider time. Qiana does Power Hour. But we are planning to go over a little hour, and I want to make sure I'm getting questions. And I want to go to Darius' question. Darius' question is: can you file a complaint against a prosecutor?
Absolutely. You can file a complaint with the Attorney Grievance Commission against any lawyer who is licensed to practice. No one has. It gets tricky with judges. That's another matter. But for lawyers, absolutely, and there are prosecutors who have been disbarred.
And if I can make it more specific, and Wanda had a question about the dates for family law going back, but more specifically, like is there rules of conduct about how a prosecutor can operate specifically? I know like detectives can lie to you. They can say, well, we got you on camera knowing good and well. So can a prosecutor be like, look, I filed a motion but she really didn't file it? Like, what are the kind of like, what standard are prosecutors held to? And is it more towards like what cops are held to, or more towards like you should really be doing things on the up and up?
I'll defer to Brandon as to sort of on the, again, I can tell you, I can tell you the ethics.
I'm doing now. Are you deferring to Brandon?
There is just to be a little Ted, there is a special rule of conduct directed towards prosecutors. It's actually called special duties of prosecutors. No, prosecutors can't lie. No, they're not supposed to speak to defendants if the defendant is represented. That's a violation of an ethical rule. So it's not like you're a prosecutor and you don't have to adhere to all of the rules of professional conduct. You do. And if anything, there's Brandon can speak to this, there are certain additional obligations you have about disclosing exculpatory evidence and all of that. But I'll defer to Brandon on sort of the on the ground stuff.
Yeah, I just wanted to hear your perspective, that's all.
Yeah, keep in mind, prosecutors, you know, they're lawyers just like any other lawyers. The only difference with prosecutors is that they're lawyers representing the state or the government or some type of local body. But they're still just lawyers, and they still have to abide by all the same ethical rules as any other lawyers do. And there's actually a couple additional rules that lawyers for the government, also known as prosecutors, have to abide by. Like Professor Rubinson said, they have to disclose, of course, exculpatory evidence. The rules also say that a prosecutor should only proceed with a case if the prosecutor believes that there's probable cause for it. I mean, and the standard of probable cause has kind of been, you know, I think, disrespected a bit. You know, they claim that anything is probable cause, but that's what the rule says. They can only proceed with a case if there's probable cause. And the lawyer and a prosecutor's job in the rules, theoretically, is to do justice. That's what their job is supposed to be. My job as a defense attorney, my job is not to do justice. My job is to zealously advocate for my client. Whether what the truth is, what actually happened, that's really not my job. My job is to try my best to either win or to get the best outcome for my client. That's not the prosecutor's job. Their job is not supposed to be to try their best to win. Their job is supposed to be to try to do justice. So, you know, there's different roles there. And in terms of honesty by prosecutors, they're not allowed to lie like the police. It's very good that, you know, you guys know that the police are allowed to lie. They lie a lot. Undercover officer, by definition, is lying. The police lie. Prosecutors are not allowed to lie. They have all lawyers have a rule called, you know, candor towards the tribunal. They can't. The prosecutor shouldn't even be talking to the person charged at all. They can't talk to that person. They have to talk to the attorney. But the prosecutor also cannot lie to the defense attorney. They can't lie and claim that, you know, they have some secret evidence on my client or something like that. They're supposed to be honest with me and give me all the discovery, give me what they have. And they can't lie to me. They can't lie to the court. That's a completely different, you know, circumstances for the police who are allowed to lie. Say
that one more time.
Police are allowed to lie. Now, no one's allowed to lie to the judge. That's something different. No one can supposedly, no one can lie to the judge. No one can lie to the jury because you're under oath. No one can lie in that circumstance. But when the police are talking to you on the street in an interrogation room, they will tell you that your mom told me that you did it. She saw you there. She's in all your friends saw you there. They're all saying it's you. So you might as well just, you know, be honest about it. They are completely allowed to do all of that outside of telling you something like, oh, if you confess, we'll just let you out. They can't do that. They can't go that far. There are some bounds that they're restricted. They can't promise to cut you a deal because only a prosecutor can cut you a deal. Police can't even cut you a deal. So they can't do that. But there are a lot of lies they are allowed to tell you.
Thank you so much, Brandon. And I want to move on to a couple other questions. We had some questions come from the OFJ office. I wanted to make sure that there were no questions coming from YouTube. And if that's the case, does the dates apply? And I wanted to make sure we lift up that we have a member, Ms. Wanderdale, who is a licensed mediator. So if any of the advocacy arms or attorneys need a licensed mediator, you can consult with her, right? You can consult with her, and we're grateful to have her a part of the Out for Justice membership. But I wanted to make sure we lift that up. I wanted to make sure we knew that when we're talking about legal, we're talking about criminal, but we also have some people on who are listening in terms of healthcare law, right? And so maybe that's another topic, hint, Matt, to bring up. But the one question was already answered. Do attorneys lie, and why or why not is it acceptable? Brandon extensively indicated no, right? That they cannot lie to the judge. Prosecutors cannot lie to defense attorneys. So no, right? This is a good one. Is it ethical for an attorney to fire you? We've been seeing more of this when people begin to speak up for themselves. Attorneys will fire you. Sometimes we don't know for what reason. So can you dive into some of the reasons that a person can be fired by an attorney?
Well, under the rules, a lawyer, well, let me start with the other question. A client can always fire a lawyer.
Yes, we know that.
But in terms of the other direction, a lawyer can fire or terminate the representation of a client if he can do it without prejudice to the client. So in other words, if it's the day of trial, it says, bye, I'm out of here. That's unethical. But if there's time to get another lawyer under the ethical rules, a lawyer can do that. There's specific reasons, but that's sort of the general, way that would work under the law.
Can anybody tap, Qiana, have you seen this in your practitioner work? Are there different ways that could, have you seen where lawyers are deciding not to work with clients? I mean, even after receiving monies, or are they, I know there gotta be different reasons why attorneys decide to step away from a case. Can you or Brandon speak to, or even any of the other lawyers? I mean, we got some attorneys on here. We had Robert Rubinson on here. I don't mean to put you on blast. We have Amon Freeman, who is the executive director of BALT. I don't mean to put you on blast. But we do have some attorneys on the call. So if you all want to raise your hand or speak to that, but I know that when it comes to Qiana, Rob, and Brandon, you all are our panelists. But go ahead, Qiana.
Well, I will say that, an attorney can't fire you because you are paying them. So, they can terminate their representation and put in and withdraw the representation. And when I have seen that, usually it's when there is a conflict of interest that has arisen, whether or not there's maybe a co-defendant in which their office has, argued for in the past or in the same case, or something along the lines with like co-defendant issues. If a co-defendant issue comes up, or if there are any issues around, the person, the loved one, not being forthcoming with information that would jeopardize the attorney's licenses. When things like that come up, the attorney has to, in essence, recuse himself or withdraw themselves from the case because they now have an immediate threat to their license and to the integrity of the case in and of itself. And so I've noticed that come up when an attorney would, recuse himself or separate. I've also noticed an increase of attorneys accepting monies when from individuals when the criminal case is at the district court level, and they accept a sum of money. Usually it's a set amount of money, and then they either get ghost after that, or once the charges have been indicted to circuit court, then they charge, or maybe they'll ghost or they'll do something like that when it comes to the circuit court case. So I always tell folks, be very mindful of your of where you are. And I always advise, I can't advise folks, I'm not an attorney, but I would always tell folks to just be mindful around going out there and hiring an attorney when it's in district court. Especially if you're looking at like a felony or something. But usually, like I said, Nicole, if you are not forthcoming with information that can seriously impact the attorney's license or the attorney's ability to practice law in your case, or if there is a co-defendant issue that arises where, it's now unethical for them to represent you, or there's a conflict that arises.
I heard something else you said, and you said conflict, or like co-defendant, but couldn't it also be some connection to your case that you as the client don't even know they have to the case, that they're like, I'm bowing out? Could it be it's too complicated for them? Could it be money? Could money be a reason why an attorney would recuse themselves, saying, okay, I don't think you have enough to pay right now, or whatever. But I just wanted to expound a little on some of the other ways. We don't know. You never really know what unless you ask the attorney why tell me why you're recusing yourself. But
and just to piggyback on that one, Nicole, wonder if there's a relationship between the prosecutor and your defense attorney.
That's a conflict. That's what I'm saying.
Do they have to expose that, and do they have to recuse themselves, or how does that work? Or does it not matter?
I could take, I'm sorry,
Go
Brandon.
ahead, Rob.
Okay, I'm sorry, Brandon. I didn't mean, I thought you were. Conflicts of interest is super complicated. There's a lot of, the basic thing with it is there's lots of ways lawyers can have conflicts of interest, a million ways. And sometimes though, the conflicts, they might have a conflict, but they can ask the client, is it okay if I still represent you even though I have this conflict? You can get consent. So the rules permit that sometimes, but for really bad conflicts, the lawyer can't continue with the representation without being unethical. But there's a million ways it can happen.
They go to law school together. It's
yeah,
just like we're in a clique, we're in the advocacy community, we know each other, right? And so
absolutely.
we might have a shared person. I might have helped somebody that Qiana knows, and Qiana might have assisted somebody that I know, right? And so it could be the same in the legal community, that they know each other, they came up in law school together. Could that be considered a conflict? Like if an attorney, a prosecutor and a defense attorney went to law school together, could that be considered as a conflict?
It could be, it depends on the specifics, but in a situation like that, the attorney should go to his client and say, I went to law school with the prosecutor, is it okay if I still represent you? You have to be specific, like how well do you know the prosecutor? Did you date? Did you just be in the same class or something? But ordinarily, it's something that the client can consent to. So it's in the client's power to say, I'm good with it.
Thank you. Can we have a question in the chat? Ms. Wanda wanted you all to repeat the dates after the conviction or trial ends. Qiana talked about these, and Brandon talked about these certain time frames you have to.
It's
right.
After if you go to trial, obviously it's different if you pled guilty, but if you go to trial and are convicted, you have 10 days to file for a new trial. You have 30 days to note an appeal. You have 90 days to file a motion to reconsider. That's Maryland.
Matt, I'm sorry, you're my co-host, and I don't mean to bulldoze the conversation. So if you would like to engage some of the questions, or we cool?
No, not at all. I think you're offering a lot of insight. The only thing I would say is I'd like to uplift Wanda's other question. Do some of those dates discussed apply to family court as well?
I really don't do any family, but I think it's the same for if you wanted to appeal in family court. I think that would also be 30 days to know an appeal.
Is that the same? Well, and that's good that you say. I appreciate you, Brandon, for saying I don't do family law, because oftentimes, and I think it's up to us too, as people looking for legal representation, to look for attorneys who specialize in the needs that we have. It's just like going to get a heart surgeon to do surgery on your hand. That's not this, attorneys also have specialized areas, right? And so I appreciate you, Brandon, for saying I don't do family law. Because some attorneys don't say that. They will just take your money and not do a good job. And then you find out later on their website, it says nothing about family law, right? So I thank you, Wanda, for that question. And what you just did was you just gave us another topic for Lawyer Up, right? That we will bring family law attorneys. But we do that. Did anybody want to add to
I Googled it, by the way. You have between 14 and 30 days. I know the 10 days and the 30 days to appeal because I stay in family court. So I know you do have that to appeal for a fact, because I'm dealing with one before, what is it, the Special Court of Appeals. I'm dealing with all that literally right now. So
Okay.
yeah.
Okay.
Nicole,
Yes, sir.
I'm sorry, I didn't mean to interrupt. Just something real quick
Go
about
ahead.
what you said. You know, it's unethical. The first rule of ethics for lawyers is called competence. So if you were doing something that you don't know enough about, like if I were representing you in a criminal case, you don't want me to do that. You want to get Brandon to do that because I'm not competent to do it. And if I go ahead and say, oh, it's okay, I can do that, I'm being unethical. So
Well, that's happening a lot in this state, Professor. So FYI, it happens on a daily basis. Attorneys take, like Qiana said, they take people's money in the district court level, and they're not always competent to handle a specific type of case, and it's happening. So you should know that it's happening. And so it's what's ethical, what's the law versus what is actually happening in our communities is that attorneys will not speak up like Brandon and say, I don't really have an expertise in family law. Let me refer you to somebody, or just say I don't have the expertise. No, you get a phone, what is happening is somebody will go Google, or somebody would know attorney from helping them with a prior case. And that's how attorneys' words get out, the name get out. And someone will call from jail and say, hey, can you represent me? I have a blah, blah, blah case. They won't say, no, I don't do that. They will be like, okay, let me tell you where to send the money. And they might show up to a first appearance, second appearance. And by the time you're knee deep in your case, you're realizing they don't really know what they're doing. Can we talk a little bit about the responsibility on the person to educate themselves about their own case, right? Because oftentimes in community, many folks seem to feel like or put their life in the attorney's hand, right? It's like, I just phase you, or you're the Office of Public Defender, so you're supposed to be the expert, do your thing, right? And so can we talk about that relationship, right? That how people should be engaging in learning their case themselves. They should know what the discovery looks like. They should, just like Darius Googled whatever, if they don't understand something. So can we talk a little bit about the ways in which community themselves can be involved in their own freedom?
I think I get a large range. I get both extremes there, where sometimes I get clients that are like, they don't really want to, they don't really bother looking through the discovery or anything. And they're just like, oh, okay, what do you think I should do? Whatever you think I should do, that's just what we're going to do. And they just, will trust me to try to do the best that I can for them. But I also get other clients that we're discussing case law together. So you definitely get the far extremes of people who want to get into the complete, all of the weeds of their case and everything. And in terms of what should someone do, I mean, obviously I'm going to do, my job and do the best I can regardless. But I think especially what's more helpful from my perspective is clients that get very involved in the facts of the case, not necessarily getting involved into like case law and stuff like that, but getting involved into the facts of the case, like, oh, okay, I talked to some other people and there may be another witness in the case. Obviously, that's very helpful because, and I think one of the questions may have alluded to this, or someone brought this up, that I wasn't there. I wasn't there. And I think that sometimes that's raised conflicts, raised some issues before with clients where they're like, okay, well, don't you know everything about the case? The only thing I know about the case is what the police said. I only have the police reports. I only have the indictment, the charging documents. I'm sure that there's some other information that you would like me to know that I don't have. So a lot of times they have information that's very helpful for me. They may know about witnesses that the police never brought up, and I would not know their existence unless you tell me. They may know that this happened right next to a video camera, or they'll think just because they told the police on the date of the incident, I automatically know that. Not necessarily. I only know what the police wrote in their reports. The police don't always write everything in their reports, especially if it's helpful for you. So that's really important. If you have a client that, will be very detailed of exactly what happened on, the date of the incident, detailed about who was there, detailed about anything that can be helpful, that's definitely very helpful to me. I would say it's, of course, fine, the clients that want to have a more detailed discussion of the statutes and the case law and whatnot, and we can talk about that. But, I find it's more helpful for clients that talk more about the facts and the details of what happened surrounding the facts of the case.
Not emotions, but facts.
Right. Not emotions, but facts, and not necessarily
right.
Case law and statutes and stuff. I can really deal with that end, but
right. Okay.
The facts of the case, yes.
Okay, I'm gonna we have another great question from Iman, but I also wanna because in the Out for Justice office all week, I had people engaging and writing down questions that they wanted to ask you if they couldn't be here, or they wanted questions highlighted. So one person said, when interacting with your clients, do you make sure they understand the law and are fully aware of what's going on? And that is, I feel like if we heard enough from Brandon, yes, I've seen Brandon work. I know that's what he does. But can we have some advice on how to make your clients or your people? Qiana hates using those kind of words, and she really pushes me to, remove myself from these European ways of that they've conditioned us to call each other clients and all that kind of stuff. So we're talking about people, we're talking about loved ones, right? Can you all talk about the ways in which you make our loved ones feel safe, right? And that means, like, how could an attorney make one of our loved ones feel comfortable with the relationship? Are there ways, are there tactics attorneys use to say, hey, I'm your attorney, I know you may feel uncomfortable right now. I know we may not know each other, but, I just want you to know that I'm here to protect you. I'm here to, like Brandon said, I'm here to fight for your freedom and save you time or whatever. And I know it's not a traditional legal question, but are there ways, Qiana, that you can suggest that attorneys can do to make our loved ones feel safe and feel protected?
Well, first and foremost, to all of the PG public defenders, stop talking to the prosecutor. Stop being all buddy with them. I know that this is, you all are probably friends. You may have gone to law school, but it is just, the really, like, I can always tell kind of sort of what's going on just by how the defense attorney interacts with the prosecutor, right? If they are really, really super friendly and like really, red flags go up for me. I don't feel safe in that environment. I don't feel really safe under that, right? At least don't do it in front of your clients. If you want to do it, on a golf course or something like that, then yeah, that's cool. But, the relationship between the prosecutor and the defense attorney, there has to be a clear line of like, I'm here for my client. I'm here to do what my client needs me to do. And I'm not here to be friends with the prosecutor. So for me, that would make, folks feel safe.
Eric, do you have a question? You put your thumb up. Oh, you just thumbs up, like, yeah, high five to Qiana.
Yeah, I was agreeing to that. Like, yeah, that's a big problem. You know,
That's not just in PG, Qiana, it's in Baltimore too, because Erica's from.
right. I guess I just wanted to speak on that as well. You know, anytime you have somebody that's representing you, but yet they seem like they are friends with not the enemy, but the person who's, you know, against you. You know, that's just, you know, anybody would feel uncomfortable with that.
Yeah. Yeah, that happens too. So thank you, Qiana, for raising that. Like, if you are a defense attorney, please say that again, Qiana. Say what you just said again, like one time for the people in the back.
If you are a defense attorney out here, your relationship with the prosecutor office needs to be strictly business, regardless of, you know, any prior ties, but there should not be no chummy, buddy. Unfortunately, in my particular case, for those who don't know, I'm a formerly incarcerated woman. I have walked up on the defense attorney in my case, really like selling me out to the prosecutor. And he, you know, walked up behind him like, yeah, you know, hey, I'm not going to say anything. You go ahead and put her on the stand. They were having this conversation in the hallway, and I was just like, what is going on here? And I fired him after that. But, you know, I mean, you gotta be mindful and pay attention to how they act with these prosecutors, y'all.
Let's go to this someone who, go ahead, Brandon.
I was gonna say that, yeah, I could definitely see that being obviously really concerning. I think it works both ways. There are prosecutors I know that give me a lot of that give me really good deals, which end up being really good outcomes for clients. There are prosecutors that, you know, that never do, and there's no reason for me to ever, you know, have any conversations with them. But if I have conversations with a client that's more likely to give my client, you know, a stet or something, then obviously that's good. I really don't know too many prosecutors personally, but I can at least see the argument that you can sometimes get you attract more, you know, bees with honey, you know, trying to get a better outcome in the end. I think, but of course that's a lot different than a defense attorney selling their client out. That's a completely different story.
We appreciate that.
As opposed to being cordial with somebody to try to get a different, you know, outcome, a better outcome for your client.
Thank you for that perspective, Brandon. We definitely appreciate that. And as people who've been on the other side, we definitely want our defense attorney to be able to definitely deliver, like use the relationship to you know, save us some time, but not using the relationship to just be cozy, buddy.
And one more thing, that I think it also depends where the case currently is. If we're towards more the beginning of the case and I'm trying to, you know, get you like a great deal or something that's different, than we're now in the middle of trial. It's no reason for us to be friends about anything. We're just fighting now to try to win the jury trial. So and that's another point that I think Qiana's talking about, a situation. They're in the middle of trial. So at that point, you're right. It is just business. At the beginning of a case, like, okay, maybe we can work this thing out, you know, offer a misdemeanor or something, that's a lot different. So I think the status of the case is also something to keep in mind.
Okay.
Can I ask a question, Nicole? Or
Sure.
This is to the attorneys and on the call, and just observing some of the conversation that has come from the discussion, and keeping in mind, like, you know, the mission for Out for Justice. Like, does any of these conversations spark ideas for potential like reform or legislation that you think would make sense for us to work on for next year? You know, we want to work on things to prevent or create barriers or rules or regulations that, you know, could, you know, provide relief for a person and, you know, facing a situation like that, so they will feel more comfortable, like, hey, there's rules or there's a sanction. And I don't know what Qiana's outcome was, or did she, you know, pursue anything against the former attorney, but, you know, those are things that we want to hear. Is like, if there's no if there's no recourse for an attorney to do that, then why would they not continue to do that? Like, how do we take the power back, I guess, is what I'm trying to say.
Yeah, thanks for asking that really good question. What I heard is we need more time to file appeals, right? That 30 days and 10 days. I heard that as a legislative push. I heard more time in family law court, right? What happens when someone has surpassed the 30 days in family law and they, now they caught up on the law, now they understand things. So that's what I hear is, more time to repeal, but I don't know what other folks feel.
I mean, it's tough from the ethics point of view for specific law changes. I'll tell you one thing that some places have done. I think this was in New Orleans and elsewhere. Public defenders said they had so many cases they couldn't competently represent their clients because they had so many cases. They couldn't spend the amount of time they needed. And so there have been lawsuits about that, saying, public defenders saying, I can't be competent here. I'm going to be unethical because I got too many cases. I'm not able to. So there are, from the ethics point of view, there has been litigation. I don't know how that might work, around here, but it is something to think about.
I want to get to Amon's question because it's a really important question. And it speaks to, I want to find it. She said, I got another question from Amon.
Right here.
Go ahead, Amon, can you ask your question about folks behind the walls?
Yeah, so I wanted to say, I know that the question probably should be that it does not have an impact, right? But especially speaking for those that have represented or have been, basically the question is, how does being in jail or being incarcerated, how does that impact the way a person is represented? And I know, and that's from either pretrial, right, where you're not able to move the way you want to move, and that's pretrial, and that's also, if you're working on appeal. Can we speak to that and how there are ways to maybe mitigate certain issues? Of course, BALT operates a bail fund, so one of those is not being behind bars, but I just want to talk to that too.
I think it has a huge impact on representation when a loved one is incarcerated as opposed to on their own personal reconnaissance. It impacts how often, frequently I can talk to my client. It impacts my client having access to certain things. I have clients that are incarcerated and, they'll be like, oh, I think I have like a phone in my apartment that may be relevant to this case. And then, I need to try to figure out, how I'm going to get that. And that key might be in their property at the jail. So there's all types of, obstacles that creates when you have a client that is held. A client that's held may have some thought about, they want to talk to me about, and, I may not be able to go to the jail that frequently or talk to them that frequently, especially to someone else who's released. So yeah, it's a huge impact that it has on the representation for a client that's held. When it's time for the jury trial, we got to figure out how to get that client closed for the jury trial. The jury can't know that the client is held. I think it impacts everything. It impacts the likelihood the client's going to plead. You're more likely to plead guilty if you're held. If they offer you a plea that says, okay, we'll let you know that you'll probably get released if you just plead guilty, as opposed to, someone who's on their own reconnaissance would be more likely to want to go to trial and fight it. So yeah, that's a huge difference in I think representation when a client's detained.
We have we're at a 5-minute check. We are going to be wrapping up, and this I wanted to give an opportunity for any one of our listeners to ask the last question, or if not, I can talk. So I have a last
Nicole,
question.
I need to say something on that, Nicole. I really do. I don't like to take up a lot of space, but I would like to say that a lot of the times prosecutors depend on you being incarcerated to strengthen their case. Case in point, phone conversations between you and your loved one when you're incarcerated, the prosecutor's office will chop and screw those conversations to make it lean towards their case in any way that they can, and they will make it discoverable. Your discovery in and of itself, when you're incarcerated, you don't have anywhere to store, you don't have a locker or anything like that. So your discovery is now compromised by your roommate or anybody else that can get a hold of your discovery, especially if you're incarcerated with a co-defendant or someone else that has knowledge of your case, or a CI, right? Or a confidential informant. So please, for anybody that may be watching this later on, your conversations while you're incarcerated, it's almost impossible to have a meaningful conversation with your loved one, anything around your case, because it can and will be used against you in a court of law. Even though you're already been incarcerated, you're already been locked up, they can still use your conversations between you and your mom, or you and not you and your attorney. You're not supposed to use that. I'm questionable about that.
Well,
but
they
can't.
They can use it. They can, if you and your attorney are having that conversation. But the minute you do a three-way, so if your baby mama three-way your lawyer in, it's no longer attorney-client privilege there. So even if your lawyer is on the phone, and if a lawyer is three-way, then that is no longer protected. But go ahead, finish up, Qiana. Yeah, so I appreciate that.
So yeah, I've seen attorneys win their cases solely, not on the evidence in the discovery, but solely on a 2-minute conversation or 2-second conversation that a loved one had with their mother about where to find something or where something was, that they can connect and corroborate their actual involvement in a particular case. So please be very careful and mindful that your discovery does not stop, does not stop once you're incarcerated. You can also be adding to your discovery while you're incarcerated.
That's a good one. That's a good one. I think do we have 2 minutes, Matt? Do we have 1 more minute for one last question, or do we have it?
Sure. Yeah. Are there any final questions from the audience? Anyone who hasn't spoken yet?
One, it's not funny. It's not a funny question, but it did come up. What do lawyers find the most frustrating when dealing with their clients? Or advocates or legal practitioners? What do you find the most frustrating thing? Rob, Qiana, and Burrell, and we only have under 2 minutes, so each of you can get like 15 seconds.
The most frustrating thing for that clients do?
Yes.
Okay.
Yes.
Too many communications. You need to communicate, but sometimes it becomes so overwhelming that given all the other people you have to help, you just don't have the time.
Yeah.
I would say there are, as Professor Rubinson talked about, there are definitely things that, the client has complete control over, for instance, whether the client takes a plea, whether he testifies, of course, whether he waives a jury trial, of course. But there are other things that, in terms of trial strategy, it's definitely within the wheelhouse of the lawyer. And I think that there's a good reason for that. I'll bring up an anecdote, I was about to do a preliminary hearing. And before I did the preliminary hearing, arguing for my client's release, my client wanted me to argue to the judge that it only happened because I'm high on PCP. And I was like, this is not a good argument. It's a horrible argument to make. And so I told him no. He was adamant that he wanted me to do it. And that's something to also keep in mind. The lawyer doesn't always have to do what the client wants. That's also not my job. My job is to, in my professional, the best way I can, advocate for you and try to fight for your best interest. And I think sometimes clients are fighting against their own best interest. And that was an example. And so, I'm arguing for their release. And then the client blurts it out. Oh, I was just high on PCP. And it pretty much destroyed his entire case. every hearing after that, that's all the prosecutor brought up, that he was high, he's a danger to the community, he's going to get high again and do this again. And so I would say that would be an example of the most frustrating. I definitely try to, talk to my clients and try to get us on the same page, but there are times where we can't, and then the client will just, feels like they are a better lawyer than you, and so they're going to decide the trial strategy and just buck you, and sometimes really ruin, and it can have devastating consequences.
What you laughing at, Qiana? Go ahead. What?
I mean, that's very true. But what Brandon was saying, and it's just very true that, we have to we walk a very thin line that we walk on when we're talking about, attorneys and what they know, and as a legal practitioner, see, it's different for us because we just throw everything out there, right? We're like, hey, talk about this and talk about this and talk about that, because the system is so rigged and stacked against us that we have to try everything, right? Something that we do is called social bio packets in our participatory defense, and I've had some attorneys look at us like we had 4 heads when we produced it to them, and then after the fact they come on board with it. It's like, hey, what about that social? So, I mean, it goes both ways. I think we have to, continuously find that balance and making sure that we're, are just like, because the system is so rigged, you got to throw all different types of things at the system, right? Because, they already have the upper hand. So sometimes, it is, very cumbersome and a very delicate process, because once you miss that opportunity, like Brandon said, that his entire case was ruined from that point. But in actuality, we should have had some type of, he was just crying out for help, right? And so this goes to show you that the system is just rigged, because that gentleman should have been offered by the courts instead of being condemned for his situation of addiction. He should have been offered some type of resources. And so, that's just my abolitionist coming out in me, but that is definitely, he was just crying out for help, and the judge and the prosecutor punished him for that. And so, but that's a larger issue for another day. So
yeah, another topic for Lawyer Up. Thank you so much. Oh my goodness, this was a great discussion. We would love to have you all back. I hope that you all have learned something from our panelists. Thank you for giving us your time, right? You didn't have to be here today, but you decided to, and we appreciate you. And so BALT and Out for Justice, we will continue to bring you these type of very holistic types of discussions about legal matters. And so don't have, Qiana, please drop your information in the chat. For advocacy arms, like, make sure you're supporting us, make sure you're showing up for us. We have a lot of work between BALT, Out for Justice, and Life After Release, and Harriet's Wildest Dreams is on. I see Tara Robinson of Public Justice Center. We work our butts off to support people in community, and oftentimes we don't get paid enough to deal with a lot that we deal with, right? But we do it because we love our people, and we want to make sure we're bringing you the tools that you need to navigate these systems, right? That's a big thing for me. We live in a system that is not designed for us, but we must know how to navigate these different systems. And that's also a part of the vision of the Lawyer partnership between BALT and Out for Justice. And I'll let Matt take us out.
Yeah, so I just want to thank everyone again for joining. I know it's, a pretty big chunk of your Thursday evening, so it's really special that you're all here. And, huge shout out to our panelists, so I want to give big ups to Qiana, Brandon, and Professor Rubinson. I think we had a great conversation tonight. And so I'm just going to end by saying we'll be doing Lawyer Up monthly. It'll be, I think we're aiming for like second Wednesdays of the month, even though today's on Thursday. Plan on second Wednesdays. Also, please join Out for Justice at their monthly meetings, which is the last Wednesday of the month, I believe.
Yes.
So there's a lot of great programming coming up in the future, and we hope that you stay engaged. And we'll be uploading this to YouTube as well. So check out BALT and Out for Justice for more information on that. To connect with BALT, you can find us on social media at Facebook, a Baltimore Action Legal Team, also Twitter and Instagram at BALT Legal. And so, Nicole, where can people find Out for Justice?
They can find Out for Justice on Instagram and Facebook at the word spelled out, OUTFOR Justice on Facebook and Instagram. And out, since Qiana is a little busy, you can also find Life at the Release on Facebook. And you can also be a part of what they have going on in Prince George's County, which is Court Watch. They are constantly watching the courts in PG. So if you're looking for something to do, best be clear. Out for Justice, Life at the Release, and BALT, and some of the other groups, we can keep you busy, right? We can keep you busy learning these systems and learning the law and educating yourselves. So yes, you can find us on Facebook and Instagram. Also go to our website, out4justice.org, and join our newsletter. That's a way that you can stay involved and stay engaged on some of the things that we're doing as well. So thank you so much for having us. Peace be with you. Hope you learned a lot.
All right. Thanks for having me.
Thank you very much.
Have a good night, y'all.